And I give the floor to my dear colleague Bojana Čučković, who is, as we heard, a member of the organizing committee and who will chair, I think, most of the panels in this conference. So hard job for you, Bojana. Good luck.
Yeah, thank you, Tanasije. And just let me also briefly introduce myself for those who do not know me. My name is Bojana Čučković. I am associate professor here at the Faculty of Law, University of Belgrade. I teach public international law and international human rights law. And I will have both an honor and a privilege to chair a number of sessions, starting with the first one. And since this is the first panel, I would just like to kindly ask you a couple of things. First, to stick to the 20-minute time frame that Tanasije already mentioned. I will have to take the role of a police officer, as Professor Padjen put it yesterday, and kindly remind you when the end of your time is approaching. We will proceed in the following way. We will first listen to all the presentations, and then at the end, we will have enough time for questions and comments. When it comes to our online participants, in order for them to be able to hear us, please use your microphones every time you want to ask something or give a comment, and we will have to do that. Also, the online participants, please, if you have any question, either raise your hand or you can also write your comments and questions in the chat, and I will gladly read it and pass it to the panelists afterwards. Let's start. We have a tight schedule and let's not waste any more time. I really have an honor to introduce the first topic for our panel relating to jurisprudential meta-science. We have Professor Padjen, and the topic of Professor Padjen's presentation is the law and the right, the non-use and overuse of philosophy. Professor Padjen, the floor is yours.
Now, the problem of my presentation is twofold. On the one hand, it is the conceptual puzzlement in the relation between the law, the droit objectif, objectives recht, and the right, the droit subjectif, subjectives recht, in both law and legal thought. On the other, it is the overuse and non-use of philosophy as because of the puzzlement and its therapy. The source of puzzlement is thought about law. A notorious example may suffice. It is Brian Tierney's criticism of Jean Villet's concept of the right. I reproduced it or summarized it in my abstract so you could see it there. Philosophy can have two uses of law and legal scholarship. As a benchmark of rationality, provided, of course, it is philosophy or philosopher that intends to be or tends to be rational. As identification of philosophical presuppositions, the non-use of philosophy fails to achieve the benefits of the use. The overuse is philosophical speculation akin to religion, which I consider to be more dangerous for practical purposes. This inquiry into the relation between law and the right makes use of philosophy, but within a different disciplinary framework. It is integral legal theory, akin to, say, Max Weber's social theory, which is also like legal theory, not sociology of law, just legal theory of a different kind. This inquiry performs the first of the following two pairs of tasks. The first pair is constructive. It includes the definition of the ideal type as a tool of inquiry and the formulation of the conceptual framework for scanning propositions of and on law or about law. The framework stipulates the relation between the law and the right and indicates their religious and social context. The basic assumption of integral legal theory is that every single human act, that is an action or its effect, is singular. Unique and unrepeatable, but similar to a degree to other acts. Hence, identification of an act is a result of productive reasoning. There are no descriptions. What we call descriptions of social effect phenomena, if they are social, not natural, are always productive conclusions of reasoning, assimilate. Interactions of humans is more or less.
Sorry, just keep talking.
We have an intruder. Maria.
We have.
Okay. Hi, Maria. Of arguments a similar, contrarian, and a fortiori. Since deductive reasoning cannot provide certainty, a general intellectual construct about interactions of humans is more or less probable than certain. Such a construct, that is a concept of an object or a proposition about relations between objects, is an ideal type. Its purpose, either explicit or implicit, contrary to Max Weber, is social change. That is transition from the present to the future. An ideal type can be useful for its purpose if it presents a possible state of affairs as something that exists or ought to exist in the future as well as in the past. The ideal type is serviceable in both the criticism of tacit presuppositions of law and legal scholarship and the formulation of new constructs of legal scholarship. An ideal type is neither true nor valid obligatory. However, while being a product of imagination, it can present a possible state of affairs, let alone possible states of affairs. Yeah. If it is informed by relevant experience, that is, if it is more faction than fiction. Legal theory, being a system of ideal types, is a handyman of other functions of legal scholarship, the other functions being argumentation, dogmatics, history, and policy. Ideal types of legal theory can be used legitimately to explain and justify law when there are no and cannot be formulated corresponding concepts of the other functions. To put it bluntly, Weber's Economy and Society is not a work of sociology, which says something about the actually existing social interactions. Of course, there are parts of the Economy and Society that do that, right? But they're insignificant in relation to the bulk of the book. But a work of sociological, economic, legal, etc. theory, which construes ideal types of a high degree of abstraction. Integral legal theory conceptualizes law, whose synonym is a legal order, as a complex institution. It consists of more elementary institutions. Every single one can be analyzed up to a point into the following two principal dimensions, natural and social. If you don't understand what it means up to a point, think of psychology and try to divide it into the social and the biological, okay? As some people try to do all the time. The latter can be analyzed in turn, again, up to a point only, into social relationships and reasons for acting. That is, into actions, interactions, and reasons for acting. You can perhaps divide them up to a point. A concrete rather than an abstract legal institution is the primary building block of law, approximately in the way it is in Carl Friedrich von Savigny's teaching. There is a plurality of legal orders. The most important ones are the international legal order, national or state legal orders, and social legal orders, for instance, of religions, localities, trades, universities, professions, parties, corporations, etc. Some of the latter are legal orders in disguise, presenting themselves increasingly as ethical, especially academic ethics, right? A convenient approach to the relation between the law and the right may be a reading, not the reading, a reading of the first Croatian and probably Yugoslav theory of human rights, published as a book. It's written by my learned colleague and friend, Mihir Matulović of Rijeka University Law Faculty. It starts with the question, why human beings have human rights? The book states that the Universal Declaration of Human Rights offers an answer, or the answer. You can't translate it from Croatian or Serbian, exactly, right? It is that human beings have human rights on the basis of their inherent dignity. However, the book finds that the rights stated by the declaration are not only general and abstract, but also vague. As such, they are not determined enough to serve as the basis for the justification of particular rights. The prime example, according to the book, is the right to life. The book argues that a human embryo is entitled to the right to life if the Declaration for Prohibition of Discrimination includes discrimination on the basis of age. Even the cursory glance at the book suffices to identify the book's explicit tenets and, in addition to some of them, their presuppositions. Although the book does not lay bare, it does imply that it presupposes a possible state of affairs. The implication is made by the assertion that human rights, including the right of life, are proclaimed by the Universal Declaration of Human Rights. The book treats human rights in the vein of analytical legal philosophy. It is compatible with legal dogmatics, the German, Italian, Serbian, Croatian, yeah? Both presuppose that rights and reasons for action differ from biophysical nature. Why don't we think of rights in terms of biophysical nature, right? As psychologists might do, right? From human behavior, not action, human behavior, observable behavior, action, which includes reasons for action, intentions, will, the feel, interest, in terms of Carl Jering's, the rule for Jering's theory, right? The statement of the declaration, which is an act of international law, answers why human beings have human rights, implies that this presupposes that law is also a reason or a set of reasons for action, rather than biology or sociology or the social superstructure, which is dependent on the socioeconomic relations to reflection or whatever, right? A human right as a reason for action belongs to a human or humans, rather than to a legal subject or subjects. Of course, human rights today belong to legal subjects. I mean, just read the jurisprudence of the European Court of Human Rights. Most of the parties are juridical persons, right? The book owes its lack of the concept of a legal subject to Anglo-American legal thought. However, the lack of the concept is characteristic also of philosophy of morality. It is sort of a moral reading of law. Huh? What analytical philosophy of law most of the time is, right? And Dworkin is not just an exception, it's just a pinnacle, almost an inevitable result. A human right does not merely belong to the law, but exists by being authorized by the law. This is the classical European thesis, right? In the sense of Aquinas or Kelsen, according to Nino in an old article 40, 50 years ago, or of standard journal legal science. Let me quote introduction to the general part of German civil law. Law in the objective sense is a rule or the entirety of rules that is an organized community of humans, that is in an organized community of humans recognized as obligatory for the behavior of individuals. Whereas the law in subjective sense means the entitlement that for an individual emanates from the regulations of the objective. There is no right without the law, okay? Which is quite compatible with the idea of sovereign, right? And the idea that all the law is national law, the state law. Huh? The book's reliance on the declaration as an emanation of rights that belongs to both public morality and public law presupposes that both the right and the law are grounded in morality. This finding is underlined by the book's account of the relation between the right to life and abortion. The book's view of the right to life of a human embryo probably differs from both the original intent of the authors of the declaration, who took it for granted that an embryo is a human being, right? And the now prevailing view of the nature of human embryo, which is like this some kind of a tumor, whatever, right? The book is wanting in two respects. First, it does not provide an analytical definition and comparison of the right and the law. It does end up with a review of Hochfeld's fundamental legal conceptions, but that's not the solution of the problem I'm talking about. That's about the right and the power and so on. The argument that they are necessary to the second, that the book does not answer the question why human beings have human rights. The argument of the book that they are necessary to the existence of a legal subject of a human, or a human as a legal subject, be it as a natural or a juridical person, cannot imply that human rights, or even rights implicit, are necessary to the existence of the objective law. Huh? It's an optional extra, especially in view of the fact that the book treats rights as an emanation of the objective law. The presuppositions recognized by integral legal theory reveal that the book belongs to the epoch in which, to quote the fundamental theologists, Christians, liberals, socialists, and even communists shared the same values, but differed and even struggled bitterly in the ways of achieving them. Not long ago, 50 years ago. The characterization given by that fundamental theologist echoes Karl Becker's classic on the heavenly city of the 18th century philosophers, a classic published in 1936 and reprinted something like 20 times. You can find it on the internet. The characterization, integral legal theory takes cognizance of the finding that we have been entering a different epoch for centuries, but that now we are in it or entering it. Yeah? There is no sharp division. In this epoch, a right, including a human right, belongs not only to humans, but increasingly to juridical persons. A right is no longer conceived of as a reason for action, but as an act of the will or an act of the field, desider ergo sum. The relation between an individual human being and other human beings has been turned upside down. It is no longer the law, either given or legitimized by a putative social contract, that emanates the right. Nowadays, every single individual creates her or his own rights, associating with others to enforce their particular rights. Emil Durkheim's noted that secularization has not resulted in the disappearance of religion, but in individualism as a new religion, 125 years ago. Okay, it's nothing new. Talcott Parsons argued that the society cannot exist if humans follow only hypothetical imperatives. Thank you. If they follow only hypothetical imperatives as assumed by Thomas Hobbes and his followers. The concept of law as an institution makes it possible to provide a solution to the problem of this paper in 3 steps. The first is the return of legal subjects, especially humans, who have been reduced by analytical philosophy theory of law, I'm thinking primarily of Kelsen, to empty dots that can be qualified by any properties. Back to law and legal scholarship. We have to return humans back to law and legal scholarship. They are returned as a part of the condition of a legal rule and legal principle, the other part being the occasional application. I'm thinking now in terms of norm and action by von Richt. The second is the trivialization of the problem by finding, now by using analytical theory as a function of institutional theory of law, the lowest common denominator of the law and the right. The trivial result is that the right, also trivialized to a right, is an individual legal rule whose occasional application obtains. The non-trivial result is that the problem is not the relation of the right to the law. It is who, why, where, when, and how counts as a legal subject, as discerned already by Riley. The third step is the realization that the sufficient reason for the existence of rights, let alone human rights, would be a necessity of rights to the existence of either the objective law and or society community. It is a delusion. I've changed that. This is a philosophical statement at the end. Delete it. It is a delusion that human rights are necessary to capitalism. Now, okay, that's been corrected. Even plain rights are weak to insurance and administrative discretion. Thank you very much. I was within my time. Okay.
Yes, thank you, Professor Padjen, not just within, but before your time. So thank you. You made
I try to do my best.
my task easier. And thank you for this intellectually challenging presentation. It seems to me that it is a very difficult task to find the proper balance between the non-use and the overuse of philosophy. So thank you. I'm looking
That's the whole
forward.
point. The mean, the Aristotelian mean, is the trick, and there is no recipe for it.
I'm looking forward to
A commentator
discussion.
Aristotle said 25 years ago, the mean doesn't tell us what is right. It facilitates to see when we are wrong. Nothing more than that.
Exactly. Thank you. Our next speaker is, maybe we can just switch places,
I think so.
but, do we have this? No, then just please stay, since we have.
Because we have to move it. You have your own. Yeah, you have to project your text on the screen, right? Are you doing to project the text on the screen? So I'm going to move to your place. Please.
Thank you. So that I will
Yes, I'm sorry for the delay. I'm just trying to share.
You remember?
Neće ona šerati, treba ja da šeram sam trenutak da... Ne vidim kako. So sorry for this technical issue. Our next presenter is Professor Isabel Trujillo, and the topic of Professor Trujillo's presentation is the legal virtue of reflexivity. Professor Trujillo, I hope you can hear us and that your paper is also visible on the screen.
Thank you very much. I see perfectly. I hope you too.
Great.
Well,
the floor is yours, please.
Okay, thank you so much. I want to share with you today my research in progress that is currently concentrated on the subjective side of the rule of law. I have recently written an article in favor of the complementarity between the rule of law and legal virtues, published on the Netherlands Journal of Legal Philosophy, of which this short contribution is a development. I will skip, I will refer to that work, and then I will skip many questions that obviously will need more explanations. The rule of law is commonly defined in contrast to the rule of man. System of rule of man are determined by human factors, and they tend risk to be arbitrary. On the contrary, rule of law systems are governed by rules, procedures, and institutions precisely with the aim of mitigating the impact of human influence. But the idea that even the best rules, procedures, and institutions could work properly without the right contribution of human agents is misleading. Rules, institutions, and procedures are needed, but it is as well paramount to shape the mindset, the skills or abilities, the appropriate attitudes of those who take part in the practice of law. I intend to work on one of these abilities or virtues, that is reflexivity. I have to make just one premise. Within the huge debate on virtue ethics, it is possible to distinguish two different approaches. One is the orthodox view of virtue ethics that elaborates a general account of human capacities and their corresponding virtues. The account is then tried out and applied in different contexts: care, medicine, business, research, and in our case, law. The alternative starts from the same practice of law in search of standards of excellence. From this point of view, the method is to look for specific legal virtues, those who better fit with its nature. Legal virtues are the skill or abilities needed for correctly taking part in the legal practice. They serve to shape the practice of law as it should be, and in my opinion, the law as it should be is well indicated by the rule of law. My contribution is inspired by some different uses of reflexivity in the legal field and their link with the rule of law. I will introduce reflexivity in international law and then in legal philosophy, and I will answer to the question who needs reflexivity and how it works. A debate on reflexivity is prospering today in international law. In this context, the discussion on reflexivity is mainly devoted to reveal the scope of scholars' contribution to the practice of international law. From the epistemological point of view, this trend is grounded in the more general reflexive turn in research, and in particular in social research, where methods used to describe phenomena contribute to the construction of those phenomena. But in the history of law, the role of legal doctrines has been an important element for a long time, before a certain development of the modern state. To speak of Jurisprudence was a way of emphasizing the role of legal doctrines in the process of building the legal practice. Reflexivity here is not only related to the knowledge of law, but also to the task of shaping the practice of law. Without going into the reasons why precisely international lawyers and scholars have arrived to the importance of reflexivity, it is easy to see that in the domestic domain, legal practitioners are also called to work in a pluralistic system, as long as sources beyond the state are becoming increasingly important. Legal normativity springs from places that are other than the state, often in competition with state law, and sometimes prevailing over it. The deconstruction of the traditional scheme of sources rejects the adequacy of purely formal solution based on traditional regulatory hierarchies. The absence of a hierarchy imposes a particular responsibility on legal practitioners that need to look for unity with the help of some common principles. The rule of law is one of these, if not the main one. From this point of view, it has been said that the classical reading of legality, acting in accordance with law, is not enough. Interlegality is a category that better represents interconnections among different legal orders. The international framework is a good lab for all these challenges. It is the beginning of an epistemic change in which the role of legal practitioners and their abilities should be studied and emphasized. In any case, not all the ways of practicing legal science are reflexive. The idea of legal science as a value-free explanation of merely existing law, eventually in the hands of those who will make political decisions, will perhaps be considered scientific, but it is not reflexive. To contribute to the construction of the practice of law, legal science must distance itself both from two different misrepresentations. The first one is the idea according to which legal science is a mere descriptive reading of facts. The second one is that of external or manipulative ideological readings of law. Mere descriptive readings do not recognize the value aspiring dimension of law that, according to the rule of law, consists in its ability to guide and coordinate actions avoiding arbitrariness. Manipulative and ideological readings of law impose external values to aspire at from outside the domain of law, for example, from political theories of justice or ideologies. Or they reduce law to raw force. In the light of reflexivity, the task of legal science is to articulate the best possible version of law here and now, where the best is referred to its value, law as it should be, and possible is referred to its factual existence, law as it is, with its rules, institutions, and roles existing. A reflexive legal science has to do with the specific duality of law between facts and values. As Julie Dixon has recently claimed, law exists both as an institutional practice and social fact, and as a normative, reason-giving, and value-aspiring phenomenon. Reflexivity concerns this double side of law and their interconnection. Coming to the studies on reflexivity in legal philosophy now, Nigel Simons has described reflexivity as the ability of making explicit or implicit appeal to the rule of law in the practice of law. The rule of law is the goal of the legal practice, but at the same time, it constitutes an immanent parameter to criticize it. This is because legal practitioners make use of an idea of law in practicing law, even if they are not a legal philosopher. This idea of law is related to the rule of law, if not even its essence. Reflexivity then guides the task of referring concrete cases to the rule of law. The rule of law must be put into effect with flexibility, awareness of the context, capacity of innovation. In my view, this kind of approach is at odds with those accounts of the rule of law that reduce it to exhaustive checklists. The lists are useful, but they must be informed by the goal that the rule of law is aiming at. Reflexivity entails also an organic and holistic approach to the rule of law. On the one hand, reflexivity makes it possible to understand that the different instantiations of the principle are originated in a core and unifying ground that is the aim of limiting arbitrariness. On the other hand, it excludes full versions of the rule of law not able to unmask hypocritical uses of the rule of law, like those claiming the compatibility of the rule of law with authoritarian regimes. Reflexivity involves both the expert legal knowledge of legal practitioners and the elementary information on law's mechanism typical of lay people. Legislators, judges, lawyers, advisors, civil servants are called to reflect on the legal action at stake and to commensurate it with the rule of law as the core of a fair social order. In this sense, the rule of law can be identified as the mark of the legal mindset. Reflexivity is not only a key of the legal practitioner's ability to absorb and translate social inputs into legal terminology, but it is the ability of finding fair legal solutions to social issues. This is possible insofar as law maintains a bond with its social sources without formalistically homologating the different demands or hiding them behind technicalities. It makes the legal practitioners the very builders of such fair social ordering that the rule of law aims at creating. In the case of lay people, reflexivity aims also at eliminating exclusive external approaches to law. Ordinary people tend to expect justice from law, simply looking at whether and how justice is done by legal practitioners. Without reflexivity, it is hard to understand that the success of the practice of limiting arbitrariness in decisions depends on every actor's involvement. Reflexivity leads not only to accept for themselves the rules by complying with them as part of the personal contribution to the rule of law, but also to demand accountability and transparency from those who exert power, as well as to participate in improving the system. The first is the principle that Gerald Postema called reflexivity, that he applies to the law itself, according to which those who rule with law and in its name are at the same time ruled by it. Reflexivity here has to do with the principle of that no one is above the law, but this feature of law has implications on those who take part in the practice of law. It requires to accept for ourselves or everybody the same rules. Obviously, from time to time, it's necessary to challenge the existing rules, and this is the task of transformative justice. It involves legal practitioners and citizens alike in the improvement of rules and institutions, each of them according to their role, and all of them as citizens engaged in social change. The difference between participation as legal practitioners and as citizens in improving rules and institutions could dispel the intention of activism, roles activism, very often the result of arrogance. Contrary to arrogance, is the disposition to teamwork that is the only valid approach for the achievement of the rule of law as a core enterprise. The practice of law does not only involve a plurality of institutional legal roles, but it engages those generally considered recipients that are called to be part of the project. It seemed to me that reflexivity at work could be well observed in the process of democratic iterations as proposed by Sila Benhabib. As she explains, democratic iterations are complex public processes of argumentation and deliberation that both legal institutions and civil society, each one in parallel and in dialogue, promote around the meaning of fundamental principles and norms to be applied in controversial contexts. According to Benhabib, this kind of processes regards mainly norms with a universal scope, such as the protection of rights. This is the topic of Benhabib. Iterative processes lead to new interpretation of the norms on rights, in her case, in continuity with their original meaning, but with new context-sensitive nuances. When the famous 3 Islamic girls in Benhabib's example pretended to be protected in their right to wear the chador at a public school in France, they were not only challenging the right to religious freedom in the French secular state, but they were also transposing private matter into the public sphere, with consequences both on the way of understanding the French principle of laïcité and on the way of understanding the role of women in the Islamic communities and in the public sphere. The same dynamic can be observed in the way in which legal practitioners and lay people take part in the legal practice according to the rule of law. It is not only the protection of rights, but also the coordination of our actions in non-arbitrary ways to be at stake. As Postema has brilliantly said, the rule of law is a way of ordering human relationships and not just a way of governing people. Reflexivity is strictly linked to fidelity, whereas reflexivity is a cognitive ability related to the rule of law. Fidelity is a solid commitment to the task of realizing the rule of law. In Postema's words, fidelity responsibilities are owed by all who enjoy law's benefits to all who are the subject to law's burdens. But this is another topic for another time. Thank you for your attention and for your cooperation sharing my file. Thank you very much.
Thank you, Professor Trujillo, for dealing with a very demanding topic in such a proficient manner, and for actually highlighting how reflexivity as a cognitive ability can contribute to Professor Özdem's understanding of reflexivity in terms of universal subjection to law. Our next presenters are our dear colleagues from Ankara University, who are starting a new doctoral course, if I'm not mistaken, and due to that, the topic of their presentation is Applied Philosophy of Law, New Name for Old Works. So let's see how applied philosophy can contribute to access to justice. Please, the floor is yours.
Thank you very much. So I need to change it from here, right? No? Yes. Okay, thank you. Thank you very much. Oh yeah, change. Yeah, thank you. Yes, as you have also highlighted, we have started a new doctoral course this year together with Professor Uygur at Ankara Law Faculty, and this initiative actually emerged from our observations how field research on access to justice contributes to philosophy of law. And since 2019, actually, we have been working on women's access to justice, sometimes collaboratively, sometimes independently, in different projects, and concepts such as law, justice, rule of law, or equality, which have long been subjects of our legal philosophical debate, have gained a deeper dimension through this integration of concrete empirical data. And our study of access to justice at both conceptual and normative levels has actually enriched our understanding of the practical barriers to justice in a non-ideal context. So in a sense, we try to explain the problems of philosophy of law by relating them to the facts. And this kind of studies actually at the application of abstract philosophical discussions in real-world context has provided us a platform for exploring applied philosophy of law, or more specifically, sometimes usually called experimental jurisprudence, or experimental philosophy of law, or shortly XJUR. It is defined as scholarship that addresses jurisprudential questions with empirical data, typically data from experiments. And this research actually often focuses on laypersons' perception of legal concepts. Some studies in this field addresses specific questions related to particular legal theories and practices, while more recent research has explored broader philosophical issues of legal and conceptual significance. So, though experimental jurisprudence is not a new area of study, the use of empirical methodologies in jurisprudence has become more prominent in recent years. We will also focus one specific benefit of XJUR studies in the context of our research on access to justice. And this specific point is to show how experimental jurisprudence can help to find out jurisprudential questions that are hard to address from the armchair. One of these studies is by Professor Uygur, titled Understanding Barriers to Women's Access to Justice and Legal Aid in Turkey. And the other study is conducted by me, is titled The Impact of Earthquakes in Turkey, Barriers to Access to Justice After the Earthquakes. Maybe I give the floor to you.
Yeah. Thank you. Actually, our study access to justice at both conceptual and normative levels has enhanced our understanding of the non-ideal theory of justice in the example of equality principle. Namely, our question is, how can we understand access to justice in the context of non-ideal theory of justice? In this context, we claim that we should insist on inequalities rather than equality to understand this concept. For this, we try to bridge the gap between empirical and normative work. This raises, the is-out problem identified by David Hume. Hume observed that normative propositions are entirely different from empirical ones. Propositions such as there are obstacles regarding women's access to justice is totally different from empirical ones such as these obstacles are wrong. We will discuss this topic exactly in the context of Turkey. But it is unclear how the second could ever or logically ground the first. Only empirical propositions cannot generate normative propositions. Accordingly, we advocate hybrid empirical and normative work collaborate to generate the premises that ground normative conclusions about non-ideal theory of justice. As you know, John Rawls makes a distinction between ideal theory and non-ideal theory of justice. According to him, ideal part assumes string compliance and works out the principles that characterize a well-ordered society under favorable circumstances. It develops the conception of a perfectly just basic structure and the corresponding duties and obligations of persons under the fixed constraints of human life. Rawls says that non-ideal theory is worked out after an ideal conception of justice has been chosen. Only then do parties ask which principles to adopt under less happy or unfavorable conditions. In that meaning, non-ideal theory of justice consists of principles which meets injustice. In that context, we claim that the principle of equality before the law does not meet injustices regarding women's access to justice. Namely, we need non-ideal theory of justice. In that context, we need to focus on identifiable injustices. Our projects insist on identifying injustices regarding women's access to justice. My project, my colleague called it Understanding Barriers to Women's Access to Justice and Legal Aid in Turkey. As you see this definition, women's access to justice needs to be understood in an expansive and comprehensive manner. It is more than ensuring equal rights in law or reforming legal system to make them efficient and affordable. It is about ensuring the sensitivity and responsiveness of justice systems to the needs and realities of women, as well as empowering women throughout the justice chain, starting with women being aware of their entitlement to equally enjoy their human rights and covers all of their interactions with justice system, including the formulation and implementation of appropriate remedies. It implies that every component of justice system, whether formal, informal, or semi-formal, is independent, impartial, effective, efficient, available, accessible, gender sensitive, of good quality, adaptable, and responsive to women's diverse needs. Reducing the impact of obstacles faced by women not only facilitates greater accessibility, but is also an essential step towards achieving substantive gender equality. Access to justice is a multifold concept interlinking the protection of fundamental rights and effective provisions of justice services to everyone without discrimination of any kind, including gender. It concerns obligations on the state to ensure accessibility, quality, and accountability of justice services, as well as legal awareness and literacy among individuals to claim and defend their rights. One of the most important elements of access to justice is the provision of legal aid, which contributes to eliminating barriers for people who lack financial means or capacity to defend their rights and supports them to claim their rights and benefits from available remedies and services. However, for many women in Turkey, coming into contact with the justice system and accessing legal aid can be a challenging and overwhelming experience. Economic, social, cultural, institutional, and legal barriers reduce women's ability to obtain equal protection of their rights, secure legal remedies established by law, and access available legal aid. Moreover, lack of awareness of these barriers among frontline professionals, including legal aid lawyers, and embedded discriminatory attitudes and gender stereotypes biases further limit women's access to justice, including legal aid and their enjoyment of their rights as equal citizens. In our study, we may draw 5 main findings. These are here. I will state them. One of them, the legal framework in Turkey is complex and piecemeal, with secondary and civil and criminal legal aid being covered in different laws, and no specific law acting out provisions regarding primary legal aid, and furthermore, there is no law including gender or other terms. Secondly, women face many challenges in applying for legal aid and during the legal aid process. At the application stage, there are many obstacles faced by women even to make the decision to apply for legal aid. Thirdly, there is lack of understanding the differential legal aid needs of women and men, and how this might have a negative impact on women's access to justice. Fourthly, women legal aid lawyers face a number of challenges in what is described as a male-dominant legal profession and system, including facing discriminatory practices in judicial process. Male lawyers tend to view women's legal needs and their right to legal aid as a women problem, and many believes that women lawyers should provide this service voluntarily. And the last one, there is a lack of uniformity in delivering gender-responsive legal aid and the ability to evaluate and monitor the legal aid system to effectively address the needs of women. There is no standard procedure for legal aid delivery in Turkey, nor is there a requirement to ensure comprehensive data collection. And now our second project.
As many of you probably know, last year two devastating earthquakes measuring 7.7 and 7.6 struck the southeast region in Turkey, and in the days after the initial earthquake, thousands of aftershocks followed, and the state of emergency was declared in 11 provinces, and these earthquakes were actually the largest to hit Turkey in the last century, and the region was also affected by heavy floods early in March, which led to other problems. So overall, according to the official information of the government, about almost 16 million people in the region were directly or indirectly affected. More than 50,000 people in Turkey had lost their lives, and more than 100 people were injured. So right after the disaster, together with UN Women Turkey, we have conducted a field study, and this study aimed to identify women's legal priorities following the earthquake. So it aimed to highlight the most significant challenges women face in exercising their rights after a disaster, and provide insights into how to support those women in fully asserting their rights before the authorities. So this research was to understand the earthquake's victims, lay person perceptions, ideas on access to justice after the earthquake. I'm not going to discuss all the results of the research, but I would like to point out one important dimension of it, which would be hard to come up with from the armchair, and which points out the importance of extra studies. So in lectures, we usually say that legal rules should meet the needs of the social reality. And by the earthquake, there was a new social reality in which legal rules were actually sometimes inadequate to define the problems or find solutions. So there was the lack of visibility of the problems faced by certain groups, and the limited or ineffective legal instruments to address them. I will give three examples for this. One is on legal aids. I'm going to make it shorter because we only have 5 minutes. As she explained, according to our legal rules, you should not have any ownership of property in order to benefit from the legal aid. But in fact, there were women who have difficulties because they do not meet the legal conditions for assistance, even though they are actually in need of that assistance. There are people whose houses were severely destroyed, could not benefit from the legal aid due to the possession of these properties on paper, but there was no house in real. And while these issues, of course, affect both women and men, there are gender impacts. I'm going to skip this part. Another example is our informed consent in terms of consenting to and agreeing with undertaking or giving up a legal step and the consequences of those decisions. For example, there is the problem of survivors of violence sometimes withdraw their complaints, and the problem of authorities' inability to examine why the complaint was withdrawn in an incident, a serious case, is quite relevant to women's access to justice. And at last but not least, the situation of irregular immigrants. They cannot operate any official complaint or application mechanisms, because if they do, they would be deported. So they have no legal personality, and that's why they usually tolerate even the most cruel treatment. And again, they are most of the time women and girls. So to conclude, I can say that both studies have significantly contributed to our understanding and re-evaluation of key concepts and principles in legal philosophy that we have previously explored in theory or thought in classes. So the notion of equality before the law maintains that laws should apply equally to all citizens. Simply put, no one is above the law. And this idea, which is also one of the meanings of the amorphous term of rule of law, is a mainstay of many current constitutions, and it's widely viewed as a central tenet of a fair and just legal system. So ideal theories of justice are also based on this equality. Two projects we have shared partly shows that this approach of equality actually is not enough regarding humans' access to justice, and within the framework of non-ideal theory of justice, we need a legal system which is actually based on gender perspective. So thank you. Very fast.
Yeah, thank you.
Thank you very much for sharing with us the very important and interesting results of your two studies. I'm particularly glad to hear that they both focus on women's access to justice. And since you are introducing the new doctoral course, let me just share an information that we are starting a new master program on law and gender here at the Faculty of Law, University of Belgrade. And it appears to me that this topic is more relevant and important as ever, especially from our Serbian perspective, and the fact that the law on gender equality is currently undergoing normative control before the Constitutional Court of Serbia. But let's leave those issues for the discussion later. Thank you very much. Our next and last speaker for the first panel is from Kazakhstan, Associate Professor Anton Didikin. The topic of Professor Didikin's presentation is Between Naturalism and Legal Interpretation, Modern Debates on the Nature of Legal Realism. So virtually, we are now going to Kazakhstan. I hope that Professor Didikin can hear us.
Yes, dear colleagues, I hear you very well.
The screen is yours. You may proceed.
Okay.
Please. Would you like to share on your own the presentation, or would you like us to do that?
Can you share my presentation from your side?
We can, but then we'll have to be the one moving it.
Yes, I sent my presentation yesterday.
Okay, if you don't mind us moving it, we'll open it now. Just tell me what the file is called, because we have many presentations here. This one. Yes, here it is.
Yes. Yes.
The floor is yours.
Okay. Yes. Okay, dear colleagues, I'm very glad to take part in this first panel session, and my report today will devote it some interesting topic. It's modern debates on the nature of legal realism from the philosophical point of view, because if we consider some modern scientific papers or works in this field of legal realism, we can find some influence of famous philosophical ideas to the methodology of realistic jurisprudence. That's why my report I title as Between Naturalism and Legal Interpretation as two methodological approaches to the legal reality and our relation to the methodological tools, how to make a cognition of this legal reality. For the first problem, I want to say that some contemporary debates in the field of legal philosophy based on one of the famous philosophical idea, naturalization of epistemology. And our colleague, legal philosopher Brian Later, tells something about naturalistic term in the modern legal philosophy. He said that while each of the major areas of philosophy, metaethics, philosophy of language, epistemology, and other have influenced by naturalistic turn in the 20th century, their legal philosophy remained untouched by this intellectual trend. And I guess his attempt to impact from philosophical conception of naturalization to legal realism and to reconsidering the legal methodology is the attempt to justify this new approach, in this case, how this philosophical idea will be useful. And for the modern legal realism, the nature and development of the realistic legal theory in this context can be based on this idea of naturalistic turn and interpretation of some epistemological argument of the famous American philosopher and logicist Willard Quine, who formulate this naturalized epistemology as a philosophical theory and methodology from the empirical grounds of any social science or a natural science at whole. The evolution of legal epistemology on the line of naturalization is significantly influenced by classical legal realism. And Brian Later is one of legal philosophers who want to imply this philosophical method. In this perspective, he needs to critique traditional jurisprudence, emphasizing the disconnect between legal theory and actual judicial practices. What is naturalism as a methodological approach if we try to apply this approach to legal realism? What the nature of this term? Now we know that naturalism has various meanings because we can talk about ontological naturalism when we think that all type of reality consists in only physical objects or physical entities which we can to research. Methodological naturalism as an approach if we try to reduce some social entities or legal entities to his natural objects. And modern discussions shows that uncertainty of the notion naturalism and very specific meanings of this term, it's really a problem to realize in legal methodology at whole. And Brian Later claims that the epistemological foundation of legal realism is based on philosophical ideas of naturalization at whole, while the process of scientific research of legal phenomena should be based on empirical facts, such as actual procedures for decision-making by judges and some types of practical activity of the administrative government bodies. I think that this understanding of naturalism, it's something new for classical conception of legal realism, because the modern realists nothing talk about something on naturalistic approach. They talk about empirical jurisprudence and empirical methodology, but not as a naturalism as an approach at whole. But what about philosophical arguments of Willard Quine? I think that the most important arguments of Quine philosophy, it's 2 points of view. The first of all, it's a critic of a priori knowledge, when challenges reliance on abstract concepts in classical epistemology is criticized by empirical science. And the second argument of Quine, it's empirical context, when we advocate for grounding philosophical arguments in empirical evidence. If we try to make an analogy between philosophical arguments of Quine and legal theory, we can talk that some types of empirical jurisprudence can be changed and replaced if we apply these philosophical arguments of Quine. For example, instead of the standard model of legal reasoning, modern legal realists try to formulate a descriptive conception of a judicial decision that functions as a tool to predict the actions of a judge in making decision dependent on some sociological, social, psychological factors. And these empirical backgrounds, if we try to change the jurisprudence from theoretical point of view to empirical. And in this case, I need to consider some most important types of theory. When we apply a classical jurisprudence from a naturalistic point of view, it's a model of legal rules, which we know in legal theory of Herbert Hart, and Kelsen's normativism. Why we need to consider this model if we talk about a legal methodology? Because some notion legal rules, it's a normative grounds of law. And if we remember how Hart tried to make a difference between primary rules and secondary rules, it's a model of legal system which based on normative grounds of law at whole. And if we can apply some empirical approach to this model, we can find some contradictions. For example, primary rules serve some regulatory function based on existing legal practices. But this legal practice is only empirical facts that we can apply if we try to justify the content of primary rules. But in the secondary rules include something like rules of recognition, as well as constitutional laws as a basic ground of legal system. What changes if we try to make empirical support? For the first time, judges apply primary rules to resolve disputes. It's only normative ground. And some non-empirical basis for secondary rules, because their legitimacy based on legal principles and legal doctrine. That's why this classical model of traditional jurisprudence cannot be naturalized. And for this model, we cannot find any empirical basis, because primary rules has a regulatory function, and secondary rules includes as a main element of legal system at whole. For the second example, Kelsen's normativism, it's another model, and this model only theoretical too, because Kelsen talk about legal normativity, and his view on a law as a system of legal rules with some logical hierarchy, and the basis of this hierarchy is a conception of basic norm, like a priori existing norm with some supreme legal force. We cannot find this basic norm in international conventions or constitutions, because basic norm it's only one of element of our legal thought, of legal thinking. So if we consider basic norm is some transcendental category essential for legal reason and legal order, in this normativist model we cannot find any empirical basis from naturalistic approach. And some thoughts of Brian Later and his view when he told about sanctions and normativity in Kelsen's theory, he cannot find these empirical grounds too. That's why we have some problems to naturalize like a normativist model of Kelsen or a legal theory of Hart as a normative grounds of the modern legal system. One of part of my presentation, it's two basic problems of modern legal realism, which we can find if we talk about realistic jurisprudence and realistic legal theory through naturalistic approach. What the problems? The first problem, it's a thesis of formalism, because some arguments of legal realists, in order to criticize the formalism in law, distort the actual practice of judicial proceedings. Because only if we comply with formal procedures in court process as provided in law is the basis to make the legitimate judicial decision. We cannot change and we cannot replace some formal procedures in law. It's essential and basic principle for legal order. That's why if we try to naturalize this realistic approach and this realistic argument, formalism only remained in legal system. And the second problem, it's a content of legal interpretation, because justification of a judicial decision doesn't depend on the uncertainty of legal rules, but based on application of legally significant argumentation, which do not require the naturalization of legal theory or legal argumentation. That's why when we read the Brian Later scientific papers, we can find some of his arguments that the basic concept of law, not naturalized. naturalized only legal theory when we try to replace them to the theory of judicial decision. I think it's not sufficient and not enough argument for naturalization jurisprudence at whole. And my basic conclusion from this my report that consists in that critics of the process to follow the formal legal rules turns the process of judicial decision making and law enactment into some kinds of political process due to influence of ideology or maybe current moral concepts. But we need to construct legal theory as an autonomous discipline with legal epistemology and legal methodology based on types of modern legal language, legal rules to analyze basic legal concepts. Thus, in the naturalized perspective, the uncertainty of law is only increasing if we talk about realistic legal theory. That's why naturalistic approach is one of possible ways to analyze the connection between legal theory and empirical data, but it's not the ground for jurisprudence and whole, as well as jurisprudence as a meta-science at whole too. Thank you for your attention. I'm ready to call your questions.
Thank you, Professor Didikin, for this interesting presentation and for dealing with a very complex issue of judicial discretion and how it influences the uncertainty of law. I believe that both academia and legal scholarship in general has a role to do in that regard, and we can discuss this during our time for comments and questions, which has come. So I would like now to give the floor to all the participants to share with us their impressions, comments, and questions relating to the four presentations that we have just heard.
Dear colleagues, can I ask my first question to the report of Professor Padjen?
Yes, of course, please. We can hear you.
Yes, dear Professor, thank you for interesting report. I want to ask you if we consider legal objects and legal reality through the legal language and legal constructions, how can we work with some results of social studies and the results of neuroscience? How do you think? Can we take these results for justification in legal theory as a science?
Thank you very much for the question. That's exactly what I wanted to add to your excellent, highly illuminating paper. Let me answer by making the two footnotes to what you have said. What the problem with Bram Leitner's approach to naturalization is. His first problem is that he avoids the problem of the concept of law. He assumes, together with 99% of Anglo-American lawyers, and together with, I would say, 99% or 100% of family practitioners in civil law countries, that law is what the state prescribes and enforces by organized force. Okay? Now, if you happen to study constitutional law in the German type of constitutional law, I don't know whether you have in Kazakhstan the German type of constitutional law.
Yes,
but
in continental
we do
legal
have
system.
In Croatia and in most Central and Eastern European countries. Most of the decisions of constitutional courts are not enforceable by force, right? They have the authority. So this is a completely different world. And if you have happened to study international law, you know that the idea of law as something that the courts, national courts do, when you translate it into theory of international law, means imperialism. It is what the American courts of law do. So this is his first problem. Can he provide a naturalistic concept of law? Of course not. What he does is he lowers down, just imagine that he is a political economist, and he lowers down all the problems of political economy, not just to mathematicize macroeconomics, but to accounting. Now, can you do political economy without accounting? Of course you cannot. But can you reduce it to accounting? Not. Can you make a fairly good naturalistic theory of accounting? That's what economists do most of the time. They always have presuppositions which are not mathematical, which are not empirical, right? That's his first problem. His second problem is that he doesn't understand that he's living in the naturalistic world. Stefan, it's a German author, wrote 35, 50 years ago on the Exactverwischen und das Recht. Look, ever since Hobbes was a philosopher rather than a social scientist as he's presented today, but he presented his ideas in a mechanistic manner because he wanted, to get the authority. Right? And look, all the problems of law are reducible to problems of custom. Kelsen in Hauptprobleme recognized are reducible to the problem of custom. And he said, okay, language is ruled by customary rules. And we cannot say, well, differentiate between the is and the ought, right? So what can you do? I've tried to find an answer in German legal theory, social theory, right? And say, what you have to rely on is not the social science. What legal realists were relying on was not social science. It's quite obvious. The practicing lawyers did not rely on Hempel's covering law model, right? They were relying on historical experience. So if you want to make a realistic jurisprudence, I fully agree with it. I enjoyed their presentation because that's exactly what they can be doing, right? And you're providing the ground for that. I love your presentation. I loved it. Absolutely loved it. It's so incisive. Most people in Europe don't understand what you discovered today. But yeah, sure. I mean, because they okay. You have to rejoin legal dogmatics and legal history in the way Carl Friedrich von Savigny did 250 years. I don't know whether I satisfied your curiosity. Is my answer satisfactory?
Yes.
Thank you.
Thank you. We have Professor Marinkovic.
Yes, thank you, Bojana. I have a couple of questions, so I will put them directly to all the participants for whom they are directed. So for Ivan, you spoke about the ideal types, and you said that they serve implicitly or explicitly the purpose of social change, that they are used for the transition from present to future. It's not really how I understand ideal types, as analytical tools for understanding reality. And then you say that they cannot be true or false, nor we can ask the question of validity.
Not we can
put the question of validity.
Yes.
I mean, ideal types are analytical tools. The question of validity is not even raised, it's not even relevant. But they can be relevant, although you say yourself they're at a very high level of abstraction. We can still challenge them from the perspective of reality, whether they correspond to the reality or not. So I'm a bit puzzled about
these two things.
Yeah, these things. Okay, this is a question for you. Now I have it for Isabel as well. If you could reflect a little bit more on the relevance of reflexivity for Postema's understanding, if Isabel is there, yeah? Okay, so well, I can put it later. Now, there is an interesting question that you have raised, Ivan, with respect to Anton's presentation, and not just Anton's, but generally the legal naturalism. And I also wonder, Anton, if you're with us, yes, whether there is interest in the legal realism, not only as to how judges behave, but how administration behaves, because Ivan said the constitutional court's judgments are not enforced, but you have a huge problem of non-enforceability of ordinary court judgments. So it appears to me that we have to go further with the naturalization of the legal theory by looking at not only how judges behave, but how the police and other administrative units of a state react. Now, that's related to this issue which you raised, and I thought of it as well. But what is more intriguing for me is your statement that the Hartian rule of recognition doesn't have empirical support. Now, for me, it has to have empirical support, I mean, not only for me in the Hartian sense, as I read it, it has an empirical support because it's a socially based theory of law. So either the secondary rule of recognition applies in Hartian, most of his examples, that that the law proclaimed by the Queen and previously adopted the Parliament is actually the law. So either the law adopted as such is applied by the courts, and then this is a rule of recognition, or the courts do not respect that rule, that only what is king in the Parliament or queen in the Parliament law, and then the rule of recognition doesn't apply, but there is some other rule of recognition. It is very empirical. So not only whether particular provision of that as this and that law, which is the primary rule, which are the primary rules in the Hartian theory. The secondary norm, the rule of recognition, also is empirically based according to the Hartian theory. So this is from my side.
I think that
the question. Oh, thank you very much. Now, as to the first question, could you remind me just?
The ideal types, there are analytical tools, and they do not serve purpose. I mean, you say that they implicitly serve the purpose of social change.
Ideal types are something we imagine, and they're useful and different from fiction if they are based on relevant experience. That's a vague statement. What it means to be based on relevant experience changes from case to case, and it's always open to argument, right? But the ideal types do not tell us only how the things are or how the things could be, but also how the things ought to be, okay? Because if you reduce problems of law to custom, then in the custom, you cannot divide neatly what is from what ought to be, right? So that's the first question. I hope I've answered your question. The second part was, sorry.
There's only one question for you, and this is to explain how the ideal types help society to helps the transition from present to future.
Oh, I'm biased in that respect. That's a long tradition from, I believe, Aristotle's distinction between, or the old Greek distinction between theory and practice. Yeah? And I think that whenever we, to Habermas, if you want me, I think that whenever we talk about society, in one way or another, we take part in that society, if you want to call it reflexivity, as Ms. Trujillo, and implicitly or explicitly, we make statements about the world that is and that does not fit our understanding how it ought to be. But you don't have to buy that. If you believe, look, if you believe that you can make descriptions of human affairs, which I disputed in the first sentence, because I say if there is a distinction between nature and nurture, if, and I say psychology teaches us every day that there is no distinction. This is why we avoid psychology. This is why we avoid psychology. But if there is a distinction between nurture and nature, then nurture exists only as made of individual units that are unique. And if they are unique, they can be identified only by productive reasoning. You're familiar with that. Bogdan Šešelj in Belgrade was talking about productive reasoning, and our learned colleague Didikin knows that quite well because it is a part of logic in the former Soviet Union, right? That is a simile, a contrario, a fortiori. And that kind of reasoning is not objective, it is subjective. And whenever I make a comparison, whenever I make a statement on the basis of deductive reasoning, I am projecting my own preconception of the world that is and that it ought to be. But of course, you can dispute it if you make a strong separation between the is and the ought, as the naturalists from Hume on have been making. I mean, I have nothing to say. I'm simply saying they can never explain the social world. We have been explaining it in Europe. Never. Okay, and this is why you have that, sorry to say, trap of Leitner's attempt to naturalization. Okay, because he can never define what law is, and he never even tries to. And if he were really a good analytical philosopher, he would go back to Hart and say, okay, why Hart tries on the third or the fourth page of the concept of law that his jurisprudence, or whatever he calls, is descriptive sociology, because he relies heavily on Peter Winch. And Peter Winch is the rogue, right? Because he said, no, sociology, sociology is misbegotten philosophy, right? Philosophy does explain everything, because what he did is he divided the philosophy of later Wittgenstein from the philosophy of the young Wittgenstein. And people who have studied Wittgenstein say, well, no, there are two sides which are inseparable. Of course that our language is also a picture of the world. How could we possibly move around if it's not a picture of the world? What kind of a stupidity is that, right? So, and the whole question of whether you can understand, I mean, your point is so sensible. I mean, I don't know why we have to make it that the rule of recognition is empirical. But in what sense empirical? You have to go from inside into the ways a community of lawyers operates. This is why this is one of the reasons why they fight first court decisions, because from the first court decisions and from the records of the hearings, you could learn their way of operating, their rule of recognition, right? That's why they hide it. Okay? When I was a kid, there was no point in going to a court of law to learn law, because the judge would not give you even his decisions. Now, all the Croatian legal first instance decisions are on computer, but they're not available outside the courts of law. Okay? And probably we'll find the same situation in Turkey, right? Why are they hiding it? And they will even give you some idiotic explanations like, we protect the privacy of the parties. I mean, that's all nonsense, right?
Yeah.
You see, we have all in common the same problem. And that was not a problem that did not exist in Italy till 50 years ago. Yeah? till 50 years ago, when the Corte Cassazione was publishing its decisions, when it came to the statement of facts, it was written omission. Not to speak of the first instance decisions, right? Okay, so it's of course empirical, but then it is empirical in a very, it is always conceptual. You cannot think empirically without concepts, and it is largely historical and from inside. And that is the internal point of view. You have to think the way the lawyers do. And you know, the American saying, who are the lawyers? The people who think differently, yeah?
Yes.
Okay, sorry, I don't impose on you.
Yes.
But that is why this type of study that the two professors from Ankara are doing are so terribly important. Why the traditional jurisprudence that is anchored in philosophy is sterile. Why analytical? There is nothing more sterile. It's an orgy of sterility. Contemporary analytical philosophy of law. An orgy of sterility, right? And this is why the cleverest of them, Raz, said all the problems were solved with the concept of law and with my additions to the concept of law. Period. That's it. And he was right. If you think that the law is what the family practitioners do before the civil courts and the petty criminal courts, well, first, you don't need any other theory. But if you really have problems of constitutional law, of administrative law, not to speak of commercial law, that where people avoid the courts of law as much as possible, paying the lip service to the state sovereignty, right? Just paying this lip service. What is the paradigmatic law today? When a country goes bust, bankrupt, and then it has a conference with creditors, with the banks, and they reprogram their debts. That is the paradigmatic case of law, right? And the second paradigm is, you know, the American interventions in Iraq, in Libya, in Syria, and so on, and the Russian intervention in Czechoslovakia, Hungary, Americans again in Dominican, and in Ukraine. That is the paradigmatic law. And it is still better than nothing. Why? Because we are still alive.
Yeah.
We are still alive. We have not burned ourselves yet, right? Sorry.
I have a question. Sorry, just let us give first the opportunity to Professor Didikin to answer his question, and then I will take yours as well. Professor Didikin, please. Yeah.
Yes,
Yeah.
Okay, dear colleagues, I agree with arguments of Professor Padjen, and I want to add something, that the basic concept of law in Hart model, it's a union and logically system of primary and secondary rules. That's why secondary rules not empirical in realistic perspective. It's another type of practice and another types of empirical knowledge. That's why I tried to talk that secondary rules are not naturalized as later tries to do. Mm-hmm.
He's wrong, you're right.
Thank you.
Thank you. Professor Marinkovic had a question for Professor Trujillo, if I'm not
Yeah,
mistaken.
for Isabel, just if you could, Isabel, reflect upon the importance of reflexivity for a little bit more on the importance of reflexivity for Postem as a concept of rule of law fidelity.
Yeah, thank you. Yes, reflexivity, you know, is the idea of, for Postema, is the idea of that no one is about the law, then that rules react on those who create it and them. But understanding the rule of law as in Postema's perspective, understanding the rule of law as a membership, as a co-responsibility among legal practitioners, but also citizens. Obviously, this relationship make important that everyone makes make their part, and then this is the, you know, the, when I accept that I am under the law, and I accept that and I understand that all of us are under the law, this the comprehension of the understanding of this circularity is the, you know, the link with fidelities. In some way, I think that from this point of view, I have a difficulty, because Postema, I think that Postema think that fidelity is the ground of reflexivity. In my perspective, reflexivity comes before fidelity. In some way, you know, we can ground reflexivity on fidelity as long as we focus on the idea of the rule of law as membership. And then this is the point, the membership, the core responsibility. But that's the reason why I am starting from reflexivity, and I am studying reflexivity. I think that reflexivity is a condition for fidelity. When I understand how the rule of law is working, thanks to reflexivity, then I am able to realize that this belongs to a feature of our interactions, that is that we are linked in some way and we are working together for something. If I may, I was writing a question in the chat, and my iPad was on fire, and then I lost a part of the debate. But I was writing a question for the two last presentations, because you both were speaking of empirical facts. In Anton's presentation, it was you know, criticizing the naturalization of jurisprudence, but admitting that empirical facts are important, obviously, in the perspective of legal theory. And in the, whereas in the Gülriz and Nadire presentation, empirical facts were important from another point of view. I think that we can make a reaction between these two ways of speaking of empirical facts. And in my opinion, it's in some way related to the precedent discussion. The point is that in feminist theories, empirical facts are important not only as starting points, but because the goal of the theory is to change the reality, to change those empirical facts. And from this point of view, it is not empirical facts are the as starting points, but it's the goal of the theory that is working on those empirical facts. And from this point of view, I think that in some way the realism is a similar theory to this to feminism, because the aim of realism was to say to legal philosopher, you are not changing nothing, you are just observing. And I agree with Professor Padjen that it is impossible to observe from outside without going into the fight, I will say. it's you know, the two approaches are distinguished by the goal of the theory, not just by the methods, by the goal that the theories are. This is a question for Anton and for Gülriz and Nadire, if you want to say something.
Thank you, Isabel. As I said in our presentations, our aims is to connect empirical and normative conceptual theories together. And then I agree with you. The aim of feminist theory is change this situation. And then I also agree with you. In this context, I said transformative justice is very important. And in our project, we didn't mention here, but we brought also the solutions to these problems. And then our aim, of course, to change this picture. But we should move from the we should move from the non-ideal theory. It is very important for us, and we try to consider it together with feminism and together with transformative justice together, all of them together. Thank you. Do you want to say anything?
No, I also agree with the professor, and the as you have highlighted, as a branch of critical legal theories, feminist theories also try to challenge the existing conceptual and theoretical frameworks. And within our projects, I also believe that we try to give or make the invisible visible and giving the voice to the silent one, and which is enough to challenge the existing understanding of rights and equality and other jurisprudential principles.
Thank you.
Thank you.
Yes, we should also draw the importance of structural inequality in our project. This is very important for us because no one aware of this structural inequality regarding access to justice. And then we should stress this point in our project.
Professor Didikin, would you like to answer the question?
Yes, thank you, dear Isabel, for your comments. I agree with you on the aim and goals of legal theory, but I don't know how legal theory can change empirical facts. That's why, because empirical facts are only a picture of social reality. And the difference between facts and reality at whole, we cannot change this connection. Well, we can make some social communication, we can influence on human behavior, but we cannot change some empirical facts. That's why, in my point of view, when we work with empirical facts, we take the part of these facts coming through legal language, and after this linguistic content, we can make an interpretation or make an analysis when we try to solve some social problems. That's why I agree with you at whole with the aim and goals, but I don't know how we can make a new connection between legal theory and empirical facts. Thank you.
I want to say something to you. I'm moving our projects. Okay, we bring some solutions, but these solutions not abstract way or from the armchair place. We use also again to change this picture empirical methods. If empirical methods bring something important solution, we use this way. Okay. It is not we find the solutions find from abstract way. It is aim and empirical methods should be integrate each other.
And one point, I think, if I have understood you correctly, we also try to, yes, empirical data or the social reality is there, but we use this to challenge the existing concept as well. I mean, we are moving from formal equality to transformative equality, for example. Now, there are different meanings of equality that we used to discuss before. So this is also a change in the theory that came from the social reality, actually.
Yeah, exactly.
Thank you. Professor Marshall, please.
My English is still poor, but I try to.
Say it in German.
No, my question. No, my question. Ivan, I learned. To Ivan, thank you, Ivan, for your sister presentation. And for last sentences or sentence, it's great. I have one question to Isabel. Isabel, I am not understand your conception of reflexivity. Fidelity to reflexivity is okay, but what is the criterion of reflexivity? You said the best interpretation of law. What is the best interpretation of law? For example, Kelsen said write about it, about legal virtue, and for him is legal virtue to be fidelity to formalism. To formalism. It is very, very important. I know this discussion in German philosophy about new conception of virtue as a concept of contingent virtue and so. But I think it is dangerous way for legal thinking or for legal theory. And great presentation from colleagues. Maybe we can speak in during this break. And Anton, I am Kelsenianerin and Habermasianerin. I am not understand. I am not. I don't understand. No, understand. I understand your approach or your opinion about formalism, but formalism is not only bad formalism or good formalism. It is not so. Formalism is a form of legal thinking, very important. For example, by Kelsen or Habermas. You can read it. Maybe you can find the other interpretation of formalism. It's all.
Thank you. I would like to ask for answers, but please, if it is possible, keep them as concise as possible because we are already within our break time.
It is impossible to be short on this answer, but I will say that you can consider my position as a formalistic position if you understand formalistic as related to the way in which law works. And the way in which law works can be also defined as following the rule of law. You can say it is just a formalistic, formal way of operational way. I cannot explain more than this. My question with Kelsen in particular, I was just criticizing his approach to interpretation. It's because it seems to me that it is not working his way of separating the search for legal interpretations by legal doctrines and the decisions by those the judges and so on. Reflexivity is the ability to put together these two things. And then against Kelsen, the decision on an interpretation is not based on an act of will, but it is based on a reasoning, a deliberation regarding reasons. This is it is not, my problem is not with the formal way of working, law working. It is about the idea that legal practitioners, in particular in this case, there are many others, are called to make decisions on the basis of reasons. That's the point. I cannot say more things now.
Dear colleagues, I have a short answer to the question. Well, I really like Kelsen model and Kelsen papers because I'm one of translator of his papers to Russian language. It's very interesting for me. And I remember the arguments of Habermas, but in my report, formalism as a principle, it's an argument against legal realism because the formalism principle and formal procedures is an essential part of legal system. That's why realistic jurisprudence doesn't consider this argument when they told about uncertainty in law. And I think that this uncertainty we can change when we're based on the principle of formalism.
It is very narrow.
Okay.
But Isabel, I didn't mention about that, but in our project, we also used feminist methodology. Okay.
With this, I would really like to conclude the first morning session and thank you all for this fruitful discussion and wonderful presentations. We continue in 15 minutes. Please be on time. Thank you.
Thank you very much for your questions.
Thank you very much, dear colleagues.